You're not supposed to leave when we go live, Rosie. You're supposed to work the other
I
way
know.
around.
I'm here though. I'm back. Go.
It's going. Hang on.
I needed lipstick.
I believe we are live on YouTube. All right. Well, we're getting started soon, people who are watching on YouTube. But here we go. All right, folks, I'm going to let everybody in. Turn off the. Okay. Good evening, folks. We're just getting started, letting people in. Welcome. This is the Renters Alliance Renter Town Hall. It takes a few minutes for people to come in through the door, so we'll just be waiting, but welcome, everyone. This is the Renters Alliance Renter Town Hall. If you're just signing in, usually takes a couple of minutes on Zoom to get everybody in, so we'll be waiting a couple of minutes, but you're looking for renter information and the Renters Alliance Renter Town Hall, you found the right place. Just getting started. If you're just arriving, just letting people in. Welcome. We're just getting started. If you're just arriving, found the Renters Alliance Renter Town Hall. We'll be starting in a few minutes. We're just getting started, folks, just letting people in. Welcome. Wait a few minutes till we get a critical mass and then we'll get started. We'll get started in just a moment or two. Thanks for your patience, just letting people in. We'll shoot for 7:05. How's that? About one more minute and we're good. A few more seconds, counting down. And if everybody saw William Shatner head up to the stars today, I had to say seemed like the right thing to do.
It's fun to watch Captain Kirk go into space.
It's fun to watch him cry. He was pretty taken by the experience. All right, speaking of Captain Kirk, not that it has anything to do with anything, let's begin. My name is Matt Losack. I am the co-founder and executive director of the Montgomery County Renters Alliance. If you're looking for the Renters Alliance Renter Town Hall, you've found it. We're going to get started. Let me give a few opening remarks. First of all, about the Renters Alliance, we are the first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. We were founded in 2010 after a couple of years at the recommendation of the Tenants work group, which started in 2008, to give a organized voice for renters in public affairs and to advocate for renters' rights in our region and in our state. And that is exactly what we're doing. Tonight, we have a few important things to tell you and some experts with us to inform you of those things. One thing I would like to focus on is an upcoming piece of legislation that is put forward by Councilmember Will Jawando and supported by Councilmember Evan Glass and Councilmember Hans Reamer, and is being considered by the rest of the council literally as we speak. And that is to extend the existing rent cap protection, the emergency rent cap protection that was put in over a year ago. Rosie, you correct me if I'm wrong, or Frank. And what it does is it requires that the rents not go up any more than the current voluntary rent increase guidelines. Right now, that is 1.4%. The reason this was put in place was to add more teeth to the protections renters needed to stay stable in their homes during the pandemic. There's a correlation between unstable housing and virus spread, not to mention the humanitarian consequences and the financial consequences and the health consequences otherwise from being evicted. But when people are stable, it was decided that that is a good way to contain or help contain COVID-19. So there were renter protections in place from the federal government and from the state of Maryland. The Centers for Disease Control, which put out one of these renter eviction protections, got involved because they see a correlation between stable housing and virus spread. I should point out that both of those orders, the governor's renter protection and eviction protection order, ended August 15th. And the Centers for Disease Control order also ended in September. So the only protection in Montgomery County for renters at this time is a emergency rent stabilization order that was put forward by Councilmember Will Jawando over a year ago. But that will expire November 15th. And Rosie McRae Moody, who is manager of the Office of Landlord and Tenant Affairs, will go into that a little bit more later on when she talks. There is a bill 30-21, which is now being considered that would extend that protection for another 9 months until next August. Unfortunately, we all know the pandemic's not over. And the consequences and impacts of the pandemic, especially economically, but also health-wise, have really been terrible for people of middle and low income families in Montgomery County and beyond. We know that this bill will protect those families the most. It's true, there are wealthy renters out there, a handful of them. According to the Department of Housing and Community Affairs, about 6% of all units in Montgomery County pay a good deal of money, like $3,000, $4,000, $5,000 a month for their rent. Good for them. But for the rest of us, and especially for seniors and for working families and working poor families and poor families, this is the only thing that's keeping your rents from going higher than what the county has deemed as a reasonable increase to cover increased overhead and costs for landlords. right now at 1.4%. So we're urging everybody to get involved with this. I'll put the contact information for the county council in the chat. If you want your rents to stay stable and how that happens, as I say, Ms. Rosie McCray Moody will address that in a little bit. But if you want these rents to stay stable and not go above these voluntary guidelines, you're going to need to contact your council member, and you're going to need to express that it is important to keep rents stable. Now, I will say that the Renters Alliance would like this to be permanent and not just on an emergency basis, but that's a conversation for a different day at a different time. Right now, we just think that this is an emergency measure. That's common sense. This is no time for rents to be lifted in order for landlords to profit. The Renters Alliance does believe that landlords need to cover their expenses, and they do also deserve to make a reasonable profit and return on their investment. We think that the existing rent increases under the guidelines are fair, especially on balance with what's needed to keep families stable and healthy during this very difficult time for all of us. So that's my spiel, and I will put the information in the chat. But now it is my pleasure to introduce our panel. And I'll start with the Deputy Director of Housing, Mr. Frank Demaray, and with Rosie McCray Moody, the Manager of the Office of Landlord and Tenant Affairs, and with Alana Branda, who is a Senior Officer at HHS. I always forget that it's a very long title, but it's a very august title. But I know everybody here is very interested in the COVID rent relief program. And so we'll start with Alana Branda, if you would give us an overview. Thanks, Alana.
My pleasure. And yeah, the title, I think they couldn't make it any longer than Deputy Chief for Services to End and Prevent Homelessness and HHS. If you write out all of HHS, you've written a whole speech there. But yeah, happy to be here with everyone this evening and give a brief update on COVID rent relief. So hopefully everyone is aware of the program. If you are not aware of the program, the COVID rent relief program was started in Montgomery County in May of 2020 to provide households who are unable to pay their rent due to a COVID hardship with assistance in paying any arrearages that you have and some prospective rent also. So we are currently in our round 3 of funding. This third round, we are using Treasury emergency rental assistance dollars as appropriated by Congress to provide assistance. And thank you, Matt, just put the link in the web page for the web page. You can go check it out. So far, between all 3 of our rounds, we have released over $47 million in direct assistance payments to households. So many of you may have received some of that. We know that there are many of you that are still waiting. Our team, while we've received over 11,000 applications in just this round. If you go back to May 2020, I think we are over 23,000 applications at this point. So we in this round in particular, out of those 11,000, we have fully processed over 55% of them. And I know our caseworkers are working days, weekends, all the time to get in touch with everyone. If you can check the status of your application by going into the portal, as long as your status does not say denied, we did not forget about you. We did not miss you. So we appreciate your patience that you are showing us. We know it is a really challenging and hard time as your arrears may grow, but we do encourage you, stay in your housing. We are going to reach out. If you do have a change of information, whether that's a change in your phone number, email address, if you did move, but you still need assistance where you've moved to, so you have a change of actual address, or if you do receive eviction documentation from the court. So that is the notification of a scheduled court hearing, the judgment from the court, or if you receive a red and white notice from the sheriff's office that the eviction is scheduled, please update us. Again, we are working to get to every application as quickly as we can, but we don't want you to be evicted or to miss out because we didn't know either how to reach you or that you have an eviction scheduled. So if you do have any updates in that regard, the best way is to email us at HSS, so Housing Stabilization Services, at montgomerycountymd.gov. If you do not have access to an email address, you can call 311 and provide that update. We do have team members checking 311 on a regular basis for those updates. Again, as long as your status does not say denied, we did not forget about you. And if you have those critical updates, please let us know. I also want to note, we are prioritizing applications. It is not first come, first serve. So I know some people have concern because my neighbor applied after me, but they got funds and I didn't. Again, we are working to get to everyone. There is funding for everyone. We are not going to run out of funds at the rate we are going and with the funds that we have. So please do not worry about that. I think those are the critical updates. Oh, I guess I should say though, if you did not apply, do not wait. we want to assist you. So please make sure to get that application in. If you have not yet applied, if you need assistance completing that application, Renters Alliance, many of our other nonprofits, or you can call 311. We will have someone call you back to assist you in completing that application. And just adding on, if you have already put in an application, besides the emailing us or calling 311 for those critical updates, you cannot add things to your application afterwards. So if you submitted an application and didn't have your income documentation with you at that time, or didn't have a photo ID, just hang on to it. As soon as your case is assigned to a caseworker, they'll review it. They'll let you know if there's anything that they're missing and they need. Once your case is assigned, please do be on the lookout. We may email you, text you, call you, send you a letter via USPS with the contact information you provided. So please be on the lookout for those for that information from us, because if there is anything missing, we do need to make sure that we talk with you, that we confirm your information in the application so that we can get that payment out. If we're not able to get in touch with you, we will have to move on to the next application, and I would hate for anyone to miss out because of that. So again, we thank you for your patience. We know this is an extremely trying and challenging time for everyone. Stay in your home. Let us know if there's a critical update, and look out for that communication from our team so that we can get your assistance processed.
Alana, could you take us through, I know you do this 50 times a day, so I know how difficult it is, but could you tell us again what the eligibility requirements are for this program and what the outside benefit could possibly be for an individual or family?
Sure. Yes, and thank you. Sometimes you do this too much that you miss parts. So to be eligible for Montgomery County's COVID rent relief program, you do have to be a county resident since August of 2020. That does not mean you have to have been in your current unit since August of 2020. So if you have moved, in the last year, trying to find something more affordable or sustainable for yourself, that's fine. Just since August 2020, somewhere in the county. Your income needs to be below 50% of area median income. And I want to be very clear about that. That doesn't mean that your income today needs to be below 50% of area median income. And the chart of all the incomes based on household size is available on the website. We recognize that there are many households, and Treasury recognizes that there are many households who may have experienced job loss, financial hardship back, early maybe on in the public health pandemic. So maybe your business closed in March, April of 2020, but in January of this 2021, they opened back up and you've been back at work since then, but you're struggling to catch up. We can look at income, your current income, so your previous 30 days, of pay stubs. We can also look at your taxes from 2020, or if at any point since January 1 of 2020, your income was certified by another government program. So maybe you were getting food stamps or Medicaid, or you're in an affordable housing unit that does income certifications. So any certification conducted since January 1 of 2020 can also be used. So I just want to be clear about that. So if you don't preemptively exclude yourself out, if your income today is maybe higher, if you have that loss during that period of time, we can work with you on that. You have to have had a COVID financial hardship. So again, it could be a loss of job. It could be you had to leave work because you had minor children who you lost childcare for. It could unfortunately be if you had someone in your household who was a wage earner, died due to COVID, and you've lost that wages from that they contributed previously to the household. So we're looking for any financial hardship related to COVID. Gosh, I do, as you mentioned, I do this so many times that I'm blanking now if I am missing anything else.
Yeah, Ilana, if also because we're seeing this in the chat, if people are finding themselves moving closer to crisis, for example, if they applied in April when they were in arrears, but they were working with their landlord, but since that time, the landlord filed, they received a court summons, and now they're receive a red and white, whatever, what should they do to keep HHS informed?
Yeah, okay. So let me go back for just a second in terms of finishing up for the eligibility. And you do have to be behind at least $1,000. That's the metrics that we're using that you are unable to keep up and that this has impacted you. The assistance is generally up to $12,000. That includes all rounds of COVID rent relief or other COVID assistance. So if you benefited from the HOC relief program that provided up to $1,800 per household, or if you received assistance, your property received assistance on your behalf from the state assisted housing program, we would count that towards the $12,000. If you have a household income that is 30% of AMI or below, we do have additional funds available to assist. We are looking in those cases for your landlord to forgive 10% of the arrears that you owe. I will say majority of larger multifamily landlords in the county have already blanket given us that approval that they will forgive anyone's 10% that's needed. Again, this only applies to certain households, so please don't assume that your bill is 10% less than it shows. But then we can remove that $12,000 cap. So that to reiterate, this goes back to my comment before of don't automatically assume you're not eligible. Put in an application and let us talk with you. Because even if you owe $15,000, $16,000, $18,000 and you see that the program says only $12,000, that's not going to help me. Please still put in an application because we depending on what we can arrange with your landlord and your household income, we may be able to help with all of that. So going back to your question, Matt, in terms of a household that maybe when they applied was not as imminently in crisis or close to an eviction, but is now. Again, please email us or call us if you cannot email us. You just email that hss@montgomerycountymd.gov. Take a picture of your red and white or your court summons or that the judgment that you have, and let us know so that we can, if we have not already pulled your application, we can get that pulled, or if it's already in a caseworker's queue, but maybe they didn't have that update, we can make sure that they have that update and get that information to them.
Ilana, if I could just tease apart a couple of those things. What are the steps of moving further into crisis? One is you've already applied because you're in a rent arrears and you owe at least $1,000. That's where we're starting. But then you receive a notice from your landlord that says you have to be out in 10 days. Ms. McCray Moody will address the issue of when you actually have to be out versus a threat to have to get out from your landlord. But then you receive a court summons, which is usually a yellow form that gets put on your door. HHS wants to know when that happens.
Correct.
And when that happens. The red and white that Ms. Branda is referring to comes from the sheriff's department. This is much more serious. At this point, the court has made a judgment against you, whether you were there or not. I'll say it now, and Rosie will say it a number of times. always go to court. But you go to court and the judge says, I agree with the landlord, you should be evicted because you haven't paid your rent, and then moves it forward. Then the landlord has to file some paperwork called a writ of restitution. And then the sheriff will then get the assignment to schedule that eviction, and they will put a notice on your door known as a red and white. That red and white is a very serious notice. At any of those steps, HHS needs to know that you're moving more seriously into crisis eviction.
Yeah, so if it's just the notice from your landlord saying, I'm intending to apply, or if you don't pay by this date, I'm going to evict. And again, I know Rosie will talk about this more too. A landlord can't actually evict you. They can request that the court and the sheriff do it. Your application status with us does not change quite at that point. But when you do have that notice from the court that there is a scheduled hearing for you to attend, when you have that judgment or you have that red and white, that is when we really need to know and share a copy of that information with us. I think the other thing that this speaks to is what we're talking about now is the COVID rent relief program. I know there may be some of you who are experiencing hardships with rent or your housing costs that may not be related to COVID. And so I just wanted to remind you, our regular housing stabilization emergency services is still available. We do eviction prevention, financial support. If utility shut off, our Office of Home Energy can assist with credits for your heating and electric bill. I want to emphasize that one because while we have beautiful kind of fall days at the moment, it will start to get colder, and we want to make sure that you have heat and electricity throughout the winter. So if you have not received an Office of Home Energy Assistance, electric or gas credit this fiscal year, so that's since July 1 of 2021, you're eligible to apply. That is income based on your household. Please review that criteria, but it is a benefit that you could apply for every 12 months for a credit towards your bill. If you have a shutoff notice for electric or gas, our OHEP office is there to help you too. If it's for water, that would come through our Housing Stabilization Office. The state will be rolling out a water program sometime, hopefully in the next month or so, but they're not quite there yet. If you find yourself in a place, again, where not COVID related, but you need assistance with security deposit, first month's rent, moving and storage costs, we may be able to assist with those also. So please reach out. The best way to reach out for any of these kind of other services is to call 311. Just let them know what you're reaching out for, and we'll have one of us call you back. There was a couple of quick questions I noticed that I wanted to mention. There was one person asking about their status in particular. I would encourage you, please log in to your portal and check your status there. Again, if it doesn't say denied, we have not forgotten you. We are still working to get to each application. If you don't have clear documentation about your COVID impact, we do have a self-certification template that you can use from our website that will allow you to just let us know, my restaurant closed. I don't have any way to contact the former employers, but I'm out of work because that closed, or whatever the situation is. There is a self-certification, and also similarly for your income, because we know many people may not have traditional paychecks or documentation that they can show. So there is self-certification documentation for that. And if you are in an informal lease situation, so you don't have a standard rent ledger, there is also a self-certification form for that available on the website. Again, there's a couple that are more specific to a person questions. So I would encourage you, check your status. You can review your specific situation with your caseworker when your case is assigned. There's a question about whether getting this assistance precludes you from renting elsewhere. Absolutely not. Our assistance what we're looking for is that you have a rent responsibility, and then we can help you with assistance with that arrears there, and with prospective rent there. If you know that you are intending to move in a month or two, our checks generally go to the landlord, and the documentation that they have is that if there is a balance left, that has to be returned to the county. But again, that shouldn't stop you from accessing housing elsewhere. What I will note, though, is that we can also assist with relocation. So if you know, this housing is not sustainable for me based on my new income that I have now, I am, looking to find something that's more sustainable for myself and my household, we can provide you with that assistance to pay the security deposit and up to 3 months rent at the new place that you identify also. So that's another option you can talk through with your caseworker. That's, dependent on your particular situation. There is a crowd applying every month. No, just one. One application. Please don't apply every month. Finding those duplicates is taking time away from our staff to actually get back to you and process cases. So one application does it. Again, if you have update to contact information, please email us. If your update is just an income update or a photo identification update or anything like that, you can work on that with your caseworker. Again, they won't. We do not deny any applications without attempting to reach out and connect with you and get any of those updates from you. So please just be on the lookout for that application from us. I think.
Ilana, just for basics again, when somebody applies, they know that their application has been received because they receive an email. Is that correct?
Yes.
Okay. And in that email, they also receive their personalized code or something in order to look at their application. Is that right?
Every application has a number. It starts with a 9. It's a 6-digit number. When you log in, your application will be automatically in your profile on that page, right there for you.
And then it will say either assigned to a caseworker or not yet assigned to a caseworker.
Yeah, there's a number of different statuses your case can be in. On our website, there's also like a cheat sheet for what all those statuses are and what they mean. Initially, your status is going to either be initial waiting, waiting for review, or it may note that it's received but working to match with a landlord or tenant. And so in those cases, you as a tenant are applying, but we are also asking the landlords to complete an application and kind of certify the rent information and provide us with their payment information. If your landlord hasn't done that yet, or if the system was not able to automatically match those addresses, you may see that status. When the caseworker is actively working on the case, you'll see that it's with caseworker for processing. If they need more information from you, you may see a status that says pending documents, waiting on landlord or tenant information. So that's kind of a clue to you also, like we check your email, check your voicemail, check the mail. We're trying to get in touch with you to move the application forward. At the end of the day, you will hopefully see that it's in payment requested, which means that we have actually sent the request to the county's bank to actually cut that check. I will take a moment to note, most checks are mailed and we are relying on USPS, right? And so please give it a couple of weeks, but don't give it a couple of months. We've had a couple of calls this week where people are just letting us know now that they never got a check that we mailed out in July. We don't want you waiting that long. So again, don't ask us the day after, because it is gonna, we do ask that you give it 2 weeks, so 10 business days for that check to come. The checks, again, are generally going directly to the landlord. So you're checking in with your landlord to make sure they've received it. Ask for an updated copy of your ledger to confirm that it was credited to the ledger. And as a reminder too, your landlords, when they completed the application and accepting the funds, they're supposed to be forgiving any legal fee, late fees, charges of that sense that were put on your ledger. So, that's a chance for you to confirm that the benefit was credited and everything is there. Once that payment is requested, the worker will send you out an approval letter that confirms for you exactly how much you're receiving and what months that rent should be credited towards for receipt. And then after we mail out the checks, we do switch the status to approved after a couple of days, usually after the checks go out.
So just to recap, for those of us who need to hear this again and again, the checks are going to the landlords. If the landlord refuses to receive the check, are there cases where the checks are sent to the tenants?
So a check can be sent to the tenant if the landlord does not engage with us and provide us, with their information of issuing that check. I will say it's rare that it happens, but it does happen. And we will, of course, issue the payment directly to you with the expectation that you're using this to pay your rent. Please don't go and deposit it into your bank account that has automatic withdrawals coming from it to pay other things. Make sure you're putting it in a secure way that you can pay your rent. This does speak to, there are some of you that may be in a situation where you have received an eviction judgment, and that judgment does allow for the landlord that even if you were to pay them, that they could still request that the sheriff execute that judgment. In those cases, we have found that generally a lot of the landlords are honest with us about that and their intention to use that. And so in those cases too, our goal would be to work with you to identify alternative housing, and then we would pay that payment to that alternative housing for the relocation, security deposit, and first 3 months rent assistance. If you're having issues, that's a great thing to talk about with your caseworker. If you expect that your landlord is going to refuse the funds, or that your landlord may take the funds but still follow through with the eviction, it does count. The amount we are allowed to give is capped by the Treasury to a certain number of months of assistance. And we would not want you to pay your current housing, then your landlord still follows through with the eviction, and we can't provide more assistance because we've kind of already reached that cap. So if you think that may be something that may happen, please have that conversation with your caseworker so that we can help you navigate the best solution and path forward for you to maximize this assistance.
So you can't receive assistance twice, is that correct?
Currently, if you received in round 1 or round 2, you are eligible for round 3. So if you got the $4,000 from us previously or a roundabouts, please do apply again. If you have already received assistance in round 3, we are not currently open to recertifications or renewals. We anticipate that process will open in early 2022. And so you don't need to apply again for that at this point either. If we see a duplicate application come in, we are just marking it as duplicate and not processing it. But when we open up the portal to accept, you've already gotten assistance, you may be eligible for more, come back, you will receive notification through the system to your email address. We will have a way to kind of screen. If you did not give us an email address, we will mail communication out that lets you know the options available to recertify, and there will be a specific recertification application. It will not be the same. It will carry over most of your information, so you don't need to spend the time redoing everything, which will hopefully make things a little smoother and quicker for everybody. So please do not apply again now if you've already received. If you are facing an active eviction, though, if you have that judgment, you have that red and white, and we had already given you assistance, that is the time to call 311 for our non-COVID eviction assistance, and they may be able to help you through there. We just can't, at this point, we are not tapping into COVID rent relief more than once per household.
Let me just unpack that ever so slightly, Alana. There's been 3 pots of money. The first pot came in when and ended when, Alana?
May 2020, and I think we cut the last check for it September 2020.
September 2020, the first pot of money ended. Then the second pot of money came in. That was from when to when?
September to, there's actually, we held back a little bit of money to help in these kinds of situations I was just describing. So you can say September till now.
But well, didn't they have to, if they were in the second pot, is that the one where we had to apply in April? Where the applications began in April?
No, that's the third pot.
That's the third one. So again,
Right,
pot
we're in the
two-
third pot now. Yeah.
All right, so let's go back to pot two, because I want to make the point about if you applied in the other ones, that doesn't count. You have to have applied in April.
Okay, so if you're going from an application date for round two, you would have applied sometime between September of 2020 and November of 2020. So that
And is
would have
that
been
done?
like-
All the applications are done? It's over? Where is it?
yes, we processed all those applications. There is no more processing of any of those applications.
So if you still needed funds and you didn't get funds from one or two, you were expected to apply when the doors opened April, what was it?
April 14th of
April
2021.
14th.
Yeah.
So even if you were on a waiting list for one or two, you would have to have reapplied April 14th going forward. So we're in the third pot of money now, and that's what they're working through. So I want to make sure that the confusion, which confuses all of us, that's how this is working right now. And that, as Alana points out, there may be other funds available and other flexibility in the program, which will be announced in this meeting and many other meetings in the coming weeks and months as they develop the program.
Yeah. I think, Matt, you raised one other really important point I want to mention. I want to reiterate again, if you did not complete an application since April 14th, we are not looking at it. So please make sure to get one in. And the application is two parts. When you click on the start a new application link on the website, it gives you a very short, it's like 6-7 question pre-eligibility screening to kind of just help you confirm, is this the right place that you want to be for assistance? When you complete that pre-eligibility screening, you'll be invited to set up an account. And when you're in that account, you actually have to start a new application and complete the full application. If all you have done is the pre-eligibility screening, you are not in the queue either. We do not, we get general metrics about who is completing the pre-eligibility, but you'll notice we didn't ask you for your name, your email, or anything until that screen to set up your account. When you go to set up your account, you will get an email from us with your temporary password. I would note that the temporary passwords a lot of times have grammatical characters in it. So if at the end of your temporary password, there's a period, that's not the end of the sentence, that's actually part of your password. You'll set up your full password, and then you'll know you're completing the full application when it's asking you for, to upload documents. Now, if you don't have all those documents with you, it's not going to stop you from finishing the application. Again, the caseworker will help collect those documentation with you. But that's when when you have to certify to the truth of the application and hit submit. If you have not done that, please go back and complete the full application.
And because we get paid to repeat ourselves over and over again, one more time, Alana, could you tell us what the obligations of the landlord are once they receive rent relief funds to the tenant?
Sure. So the landlord, when they complete their application, they are also certifying to the fact that they will forgive any legal fees, late fees, court fees, any of those kinds of penalty charges that they have placed on your ledger, that they will cancel any current eviction actions, and they will not proceed with any new eviction actions until a minimum 30 days after the assistance period. So if we provide prospective rent and we have paid for your November rent, so the assistance period would end then on November 30th, and they could not file for an eviction then before December 31st. I do want to note that excludes breach of lease for safety reasons. And that if you have an expired or an expiring lease, that they offer you a minimum 90-day extension. If they have to offer it, it is your choice to accept it. The reason that was put in was to try to help you, because there are a lot of tenant holding over eviction filings. So even if we have paid your rent, the landlord could still file against you if you are not under a lease. And so that was the intention with that. So again, if your landlord completed their application, they certify to all of that. We also do reiterate it in the approval letters that go out.
Thanks. And again, to repeat, if you haven't said so already, if you don't qualify for the COVID rent relief program, but you're facing eviction, there are some funds available through HHS. Could you tell the folks who are not eligible because they didn't lose their job because of COVID, or a spouse was affected because of COVID, or whatever their financial situation was, not directly or even indirectly affected by COVID, but they are in arrears and possibly facing eviction, what resources are available to them?
Yeah, so we have, pre-COVID and operating during COVID, we have our housing stabilization services, which provides eviction prevention. We can provide grants to pay to stop the eviction. And we can work with many of our community partners to help supplement if it exceeds the allowances that HHS has. So the best way to access those funds is to call 311 and let them know you are experiencing an eviction. They may try to direct you to the COVID rent relief. So just be specific and say, this is not COVID related. I need the regular eviction. You will hear from one of our either our triage, or you may hear directly from one of our social workers, depending on staffing that day. And they'll talk through with you what's going on, where things are, and work with you to come up with a plan. That plan may be, as I mentioned, it could be funds to help stop that eviction. It may also be funds to help you with moving and storage if that eviction is going to happen. And we want to help make sure that you can save your stuff and have it out of there before the sheriff were to come. Or it may also be assistance with security deposit and first month's rent. Again, if maybe either the eviction is going to happen, or you recognize that this is not a sustainable place for you, we can work to help you get set up elsewhere. So that all goes through, again, 311, let them know you're experiencing an eviction. 311 is also the place you can call for utility shutoff, or even if it's not shut off, or just to get a call back from our Office of Home Energy Programs for utility assistance for that. So I think that covered all of that. I will, Matt, as you turn it over to Frank and Rosie, and to everyone here, I will check the chat and the Q&A and make sure if there's anything that we missed, I will work on answering those there.
And given the interest and intensity of this group this evening, if you could stick around, because I have a feeling we may cross back to you in the upcoming conversation. So thank you for that, Ilana Branda from HHS. A lot of information, very important information, especially if you're in rent arrears and possibly facing eviction. Stay on top of it, folks. It's important. Even the best bureaucracies require us to pay attention with what's going on. So check out your application status. Make sure you keep HHS informed if you receive a court summons or a sheriff's notice, God forbid, and let them know so that they can prioritize your application. And if you have any difficulties at all with any of that, you can contact us at info@rentersalliance.org. I'll put it in the chat. And then, of course, there is other resources out there and other groups and parts of the county government who can also help. And so with that, let me turn it to thank you, Ilana, and let me turn it to the Deputy Director of Housing, Frank Demarais, to introduce himself and his team.
Okay, so I'll say thank you to Matt. Thank you, Ilana. That's the fundamentals of our primary support is the rent relief. Now I'm going to touch on the other support. A lot of it is how you can access information, how you can get support from organizations, Renters Alliance and others to help you navigate the rent relief and also navigate other aspects of managing your housing, your lease, your property condition. So Frank Demarais with Department of Housing Community Affairs. The Department of Housing Community Affairs It focuses on supporting tenants and landlords in managing and maintaining their relationship, the property condition, the relationship through the lease, and adhering to all the requirements that the state and county requirements for their property. So tonight we're going to touch on a number of topics that are particular to the current period, but the information we're sharing is available at our website. So you can find a lot of this information. We have a renter's handbook that covers a lot of the rights and responsibilities for landlords and your rights as tenants and the landlord's rights. That along with our housing code handbook, which describes all the conditions and requirements, housing code, safety, health aspects of the property, are available at the DHCA website. You can search Montgomery County Housing Department. It'll take you right to our website. I am putting in the chat right now.
You're on mute, Frank.
Did I just go on mute? Okay, I don't know how that happened. So the link that I just posted has information, montgomerycountymd.gov/renters, that lists the organizations in addition to the county resources we're going to talk about that can support you. So as you're trying to understand, and we know this is very complicated, everything Alana spoke to there, is correct and helpful, but it's complicated. And so Renters Alliance, Housing Initiatives Partnership, Latino Economic Development Corp., the CASA organization have staff who will work with you, help you understand, help you respond to your rent relief application process. They'll help you work with your landlord. So they will, you don't have to do everything by yourself. You can get direct assistance there. Rosie McCray Moody in a moment will talk about our Office of Landlord Tenant Affairs, which also provides support for your response, for your questions and respond to you and your concerns on your landlord-tenant relationships. The other key thing that's available, and again at that Montgomery County MD/renters, is the contact information for legal representation assistance. So the county has contract with, and lawyers are available to respond to your calls, to help you understand if you have a summons to court, how to prepare for that. If you receive judgment, how to work with the judgment process. They'll help you in advance of court, and it's very important to reach out for legal assistance before you go to court. There are things that you can prepare for, defenses that you can develop. The protections that had been available for over a year with the federal and the state protections against eviction, allowing deferral of eviction action if you had a COVID impact, expired in August. While those are not available, depending on your circumstances, you may have legal approaches that can help you work through the issues with your landlord, but at a minimum, it can help you understand what you need to do and how to work with that system. The process is very complicated, but there are attorneys that will respond to your call. If you need assistance at court, they'll arrange that with you. There is legal assistance at the courthouse. There's a help center with an attorney on site. Their phone numbers to reach them, again, ahead of your court date. So I just want to point out, there is information. The approach is, we're hoping that you will get that information before you face the judge or deal with things in court. And as often said, you don't want to learn all this when you show up at court. We really strongly recommend take advantage of these free services to help you navigate that process. I'm going to let Rosie McCray Moody address the basic issues associated with the current environment, the COVID environment that affect the landlord-tenant relationships. And then I'll speak a little bit about our housing code enforcement, current coverages, our responsibilities, and our support for anyone that has questions or concerns. And as you hear any of these and you put questions in the chat, we'll try and answer them in the chat, but we'll speak to the ones that seem to have the most number of questions coming up. So with that, I'll ask Rosie to cover the Office of Landlord Tenant Affairs, landlord tenant rights components.
Hello, everybody. My name's Rosie McCray Moody, and I'm the manager of the Office of Landlord Tenant Affairs. And we basically help mediate disputes between landlords and tenants and help inform everybody of their rights. And you do have rights, whether you think so or not, you do. They may not be all the rights you want, but they're there. Right now, the main thing, our main focus is on evictions and those facing eviction for failure to pay rent based on losses due to COVID. Again, Alana said lots of things, but that's where you start. Call 311 and ask for COVID rent relief. That's your best bet, because if you owe a lot of money, that's where you have to get it from. No other office can get you that. So that's one. Your landlord cannot just put you out. So if the landlord says, if you don't pay me, you have to get out in 10 days, that's not true. The only way you can be evicted is by court order and in the presence of the sheriff. If you haven't been taken to court, the landlord can't just lock the doors and put your things outside. That's not how it works. So if he's telling you that, he's just threatening you, call our office. So, and if he tries to do that, call the police, because they're not supposed to do that. Landlord's not supposed to do that. So
and let us know too, because we do not, we support tenants, and that is one thing that really upsets us. So let us know if your landlord is moving to evict you without a court order, without the sheriff's department. Immediately contact the Office of Landlord and Tenant Affairs. And if they're in your house or disturbing your property, call the police.
Call the police. And so they can't put you out. And if you get a notice to vacate, that's what it is. It's a notice to vacate. It is not an eviction order. It's just a request from the landlord for you to leave. If you don't leave, the landlord has to take you to court and sue you for tenant holding over. And I can tell you now, if you're sued for tenant holding over, there are not a lot of defenses for it. If the landlord gives you proper notice and tells you to go, leave, you have to go.
You better explain what tenant holding over is, Rosie.
Tenant holding over means that your lease is over or whatever, and the landlord has given you notice to vacate and then you didn't leave. Or you gave the landlord notice saying you were going to leave and then you didn't go. Because just because you change your mind, the landlord doesn't have to take it back. You put it in writing. You said you were going to go on September the 30th, and then it got towards September the 30th, and you decided that maybe wasn't a good idea. The landlord doesn't have to take that back. The landlord doesn't have to say, well, okay, you can stay. He can say, no, you have to get out. He might have done what he was supposed to do by law, mitigate his damages and try to find a new tenant. When he's found a new tenant now, you need to leave.
Okay, but for the majority of tenant holding over, they have to give you 90 days, 90 days notice.
Wait a minute. If that's what the landlord has to do. So if the landlord wants you to leave, he has to give you 60 days notice. The 90 days is for a rent increase. The landlord has to give you a 60-day notice, whether it is a single family or a multifamily, because the law changed. So you are entitled to a 60-day notice to vacate. And it should coincide with the rent payment cycle. So it should be given on or before the first of the month if your rent is due on the first of the month, and run through the end of that month.
Sorry, Rosie, didn't they just change the state law to 90 days?
No, not for it's 60. They changed it to 60. For single families, it was 30, but they changed it to 60. Only in Montgomery County was it 2 months, and now it's 60 days for everybody.
All right, I'm confused. For some reason, I thought they extended it to 90 days. I'll go back and check. But anyway, for safety's sake, at least 60 days notice.
Okay, and that's for single family and multifamily properties. So it used to be just 30 days if you were in a single family, but now it's 60 days for everybody. So if your landlord gives you proper notice and you don't leave, he then has to take you to court for tenant holding over. And if you don't have anywhere to go and you stay, you have, you can stay until he gets you to court, and then he'll have you evicted. But if you stay, you still owe rent. And if you're stopping somebody else from moving in and they incur costs, they can come after you as well. So tenant holding over is not without its pitfalls. If the landlord gives you a notice, he can also evict you for breach of lease. If your lease says you can't have a pet, or you're only supposed to have 3 people and now you have 5, or you're not supposed to have pets and now you have a Rottweiler, or you let your cousin Simi stay with you and now he's, smoking marijuana and disturbing all your neighbors, the landlord can give you breach of lease notice for all of those things. And then it'll be up to the court to decide whether or not you should be separated from your housing. So these are all the ways you can get evicted: failure to pay rent, tenant holding over, breach of lease. No matter which one you're sued for, if you get a court notice, go to court. Because if you do not go to court, you lose automatically. The landlord may be wrong, but if you do not go to court, you lose. And as Frank said, there's a help center at the court, and they have attorneys on site, and they have a number, and attorneys answer that line all day. And you can call 311 and ask for the Office of Landlord Tenant Affairs. We are on duty daily, 8:30 to 5. And although they tell you somebody will call you back within 48 hours, we usually call people the same day. So there's help out there for you, and there are people there to answer your questions. Please call. Our offices are open 8:30 to 5 daily. Somebody will talk to you. So there's no reason for you not to get your questions answered. And as Frank said, the catastrophic emergency declared by the governor expired. All those protections expired August the 15th. And so when Mr. Jawando put his bill forward, he said 90 days after the end of the catastrophic emergency, rents could be raised above the voluntary guideline. That'll be November the 15th, unless the new bill that Matt told you about at the beginning of this, Bill 30-21, passes, and then it will be extended for some other period of time. At this point, on November 15th, your rent can go up in excess of the voluntary guideline. So just, watch out for that. And like you said, pay attention, contact your council person, and just, keep track. We'll be keeping track of it.
Rosie, I think I looked it up. It does say 90 days if you're on a year-to-year. It's 60 days if you're on month-to-month in terms of the notice to terminate the lease. But we will ascertain that for sure.
Most people don't have a year-to-year lease. They have a lease that expires and then they sign a new one, it's annual. So, but a year-to-year, it regenerates every year.
Okay. Well, I just want to make sure, because the only defense for tenant holding over in court is that you got improper notice. So if you got, 30 days and you only got notice that your lease is being terminated with 30 days notice, it doesn't count, and they cannot evict you under those terms, because
but
there's
if you
so
don't go to
protection.
court, you
Pardon
lose.
me?
So yeah, and that's true. But if you don't go to court, you lose. So always
Absolutely.
go to court.
Right.
And please, there's, like I said, there's a help center in the court. So there's an attorney on duty all the time. They have attorneys on the phone all the time. There's legal aid. There's the what is it called? Homeless Persons
Representation Project.
Project. They have attorneys. And so those phone numbers are on our website. There are people out there to help you. That's all, because everybody here wants to help you as much as they can. So use your computer, use 311, and the information is there for you. Just reach out.
All right. If you have questions for Ms. McCray Moody, please put them in the chat, or concerns. I would ask everybody to please be civil. You know, some people very passionate out there, and I don't blame you. Please let any vitriol come from me. I'm the best at it. I will filter everything that needs to come out. But please be civil, but ask your questions in the chat. And Frank Demaray, can you address some issues of code? What is happening with code now? They were dormant for a while during the pandemic. Now they're out in the field. There are annual inspections, and then there are specific issues of code enforcement. Frank, can you address that for us, please?
Yes, and we have a number of specific questions in the chat that I'll try and get to. The current state of our code enforcement is that we're operating on the same basis as we operated pre-COVID. During the COVID period, we did not do interior unit inspections unless there was a health and safety issue identified. So we had established a structure of inspecting all properties in the county, then identifying which properties had a level of code violations that warranted every year inspections or every other year or every 3-year inspections. So we are back to our schedule. We have identified the properties that will be inspected on an annual basis, and we're now back to scheduling those as well as those that had every other year inspection. So we are doing scheduled inspections. It was a very specific question. Someone who had received a notice that a scheduled inspection was planned and that the tenant, renters in any unit, could opt out in recognition of the health concerns and concerns about people coming into your home. You have the right to opt out of that inspection. We attempt to inspect a certain number of units in each building, but we recognize and honor any tenant that chooses not to have someone come into their unit for a scheduled inspection. If you contact DHCA, call 311 or go through our website and the complaint process there, 311 to file a code complaint. This would relate to any item that's a health and safety issue, anything that you believe is not being repaired after working with the landlord. It's very important to start with working with the property management and the landlord to ask for things to be repaired, to have a response from the landlord, to give them an opportunity to address it. If you are not getting satisfaction, or if you have a health and safety issue that is not being addressed, you need to file a complaint. And when you get a complaint registered, you'll get a service request number, and then you will be contacted. They are prioritized based on the type of issue that you identify, and health and safety being the highest priority. But we have a team of housing inspectors assigned to different property types in different sections of the county. They will schedule to talk to you, to contact you, and then your landlord determine the situation, try to get a resolution as soon as possible. They will come out and inspect the property to see what the issue is, and we will enforce the requirements of the county housing code. I mentioned earlier, you can look up the housing code handbook, which has been revamped. It's interactive, and we hope that it's much more readable than versions we had previously. But you should contact, and we will respond on any housing code concerns. So that's the fundamentals of the housing code program. But I will try and get to some of these questions that I'm answering in the chat.
Frank, if I could just jump in on one thing, and then maybe this should go back to Rosie or Alana. But if they've received, if a landlord has received rent relief, as Alana pointed out earlier in her discussion, the landlord is going to forgive late fees, waive or dismiss the court fees and any eviction that is pending. And they're going to offer you up to 90 days, Alana, jump in if I'm wrong, up to 90 days of continuing your lease after it expires, if need be, if you choose to pursue that. I don't believe, Rosie, you answer this, but I don't believe the landlord is required to offer you a renewal beyond that.
No.
And so, unfortunately, and we, the Renters Alliance, will mention this as often as we can. We have for years pursued what is known as just cause eviction law. That is a protection that exists in many places where there are long-standing renter communities like New York and Washington, D.C. and San Francisco and Seattle and other places around the world like London and Paris that have long-standing renter populations and therefore long-standing common sense renter protections. Maryland is pretty new to this. We just sort of became, outside of Baltimore, a renter-dense community. Look around Silver Spring, Bethesda, Rockville, there's a lot of apartment buildings being built. Now we've gone from 23% renter about in 2007 to nearly 40% now. But the infrastructure that protects renters has not caught up legally. Just cause eviction law would say, if we had that protection, that a landlord will have to renew your lease automatically each year or each month or whenever the renewal comes up, automatically, absent a just cause not to. So obviously, the same reasons you're going to get evicted for now, if you're abusing the property or creating criminal trouble or threatening others or some other reason that any reasonable person would say that person's got to go, all of those reasons would be just causes. And then there are a few business reasons, like the landlord's no longer going to rent that apartment anymore. Say it's a small landlord and he wants to move in his elderly mother into that apartment. That would be a just cause. Or a larger landlord that's going to renovate an apartment complex to such a degree that'll be unlivable for many months at a time. And so everybody with proper notice is going to have to move out because they're going to do construction that will make those properties, those apartments no longer livable. Those would be included as just cause. But absent any of that, we believe that a landlord is going to rent an apartment in perpetuity. And as far as I know, most landlords would like to collect rent even after you're dead. That if they're going to collect rent or keep the apartment on the market in perpetuity, that unless there's a good reason to cause a family or an individual to have to move out, we think that the just cause protection should exist. But it does not exist in the state of Maryland at this time. So all of you who are out there listening to that, every year when we try to put this forward, we hope that you'll support us. But right now, it does not, that protection does not exist. What else, Frank? There were some other concerns in the chat. I do want to add also one other thing. Everybody should know this. If you don't already, let me tell you. This is the county has a lot of very good people working for it. And not everybody knows everything all the time. And so you have to be in charge of your own destiny, so to speak, in some ways. The Renters Alliance is here to help navigate the county. We work with the county, been working with the county for over a decade. We know the players, we know how it works, we know how it doesn't work. And we can help make sure that you get the resources that you need if you're not getting them. We'll also tell you that if you're making demands that can't be satisfied reasonably, we'll tell you, you shouldn't be asking that, or you're being unfair, or you have responsibilities that you're not paying attention to. But if you find that you get in touch with somebody on 311 or in one of the county offices that's not giving you the correct information, or you feel that common sense, this is not right, or I do have a case, they told me I didn't, now I think I do, then consult with us and we'll help navigate that. Just because someone says no, doesn't always mean that it's no. Sorry, Frank.
Well, the one thing I see in quite a number of the code-related questions, I think the formal answer to most of this is to contact and register a complaint. I'm trying to explain in the responses. We do need specifics, and we need it coming through the complaint process. It'll get registered, it'll get scheduled, and you will get a response. So if you have issues with mice, or you have issues with water or mold, or items in your unit not working and they're not being repaired, it is a call to the code through 311, or you can connect through the website. The questions about these scheduled inspections, which are very large numbers of inspections in units. It's very difficult to schedule each one for a certain time and hour, and anyone that wants to opt out of that, in the card that comes with it, it says to, again, call 311, and you can connect into the code department. You can identify your property address, and ask to opt out and to not be included in the inspection. So it may sound like it's a catch-all, but it is a robust system the county manages where they attempt to connect you with the services. And that's why the more specific it can be, the better we can connect you with the most appropriate services. So anything related to health and safety or operations of your unit, you're asking for code support. The items that Rosie was speaking to, you're asking for landlord tenant support. There is some overlap, but we hope we can get them, get you connected to the right people as soon as possible.
Rosie, this may be for you, but if a landlord is refusing to take the rent or is taking the rent and not cashing the checks, I have a common sense answer, but maybe you want to address this. Rosie, you with us? Or you have Amazon Prime delivering cakes at the front door? Earth to Rosie. Well, if Rosie's taken off for a second, let me answer what I think I know. Anybody else chime in if you think you've got a better answer. First of all, whenever you pay your rent.
I had an emergency.
Fair
Call
enough.
311. Call 311 and we'll call your landlord, file a complaint. They can't not take your money.
But if they take the checks and don't cash it, then what?
We can call, to find out, because if they don't take your money, if you can prove you gave it to them and they don't cash your check, and then they try to sue you, you'll have evidence that you did pay it. So keep your receipts, keep your checks, keep everything you have. Every time you make a payment, get a receipt. The landlord has to give it to you if you ask.
And if they don't, then contact a landlord tenant at 311. Contact the Renters Alliance at info@rentersalliance.org, and we'll make sure that that happens. But I say this all the time to renters: your landlord is not your friend. They're not your enemy. They're not your friend. They're in business with you. You have a contract with them, and in exchange for your paying rent, you're entitled to certain services, and you have certain rights. And so, if you have to exercise those rights and demand that you get the services that you're paying for. So, if you're paying your rent, you're entitled to a receipt. If they don't give you a receipt, then, ask nicely and then contact us. We'll make sure that that happens. Many times it's because a property manager, not necessarily the landlord, has no idea what their obligations are or what the law is. Another issue that the Renters Alliance is working on. And sometimes it's just, they just don't understand what to do, or they don't have good business practices. So definitely take care of that. I will say one thing that would worry me is that you'd pay 3 months worth of rent with 3 checks and then have the landlord suddenly cash the checks. Make sure that that money is still in the bank. Sorry, my other phone ringing. So that's one question. The other was, Rosie, can you address the issue of smoke and pot smoking in buildings? Keeps coming up.
Okay, here's the thing. It's not illegal to smoke marijuana, recreational use. And if you call the police, they're really not going to do anything. And most apartment buildings, the ventilation systems aren't that great. So if I'm smoking in 203 and you live in 303 or 205 or 207, you can smell it. And I'm sure it disturbs you, but the apartment building is, their ventilation systems aren't wonderful. So it's not a lot that they can do to help you. And even in buildings that are supposed to be smoke-free, they're not sitting in everybody's apartment every day. So they can tell you that you shouldn't smoke, but they can't assure that nobody is smoking. If you can pinpoint who it is and when it is, they can give them a breach of lease notice, but they have to go through the process of evicting them if they don't leave or stop. They can't just throw them out because they're breaking the rules.
Rosie, as we begin to wind up, please tell us again the difference between code and landlord tenant. What are the differences and how should people complain if they have a complaint? What should they know to do?
If something is broken, if you have an infestation of mice or roaches, or your stove isn't working properly. That's housing code enforcement because it's something that needs to be repaired. If the landlord is charging you a fee that didn't go in your lease, or that's not in your lease and now he's trying to charge you a fee, or he's coming in your unit without giving you 24 hours notice, or you didn't get your security deposit back when you left, that's landlord tenant.
Right, and I will, I think I put it in earlier, but in the chat are the links to both of those complaint processes. But also both complaint processes expect, as we would, that you first contact your property manager or landlord with that complaint. Give them a chance to fix it or resolve it. You're in business with them. Like I said, I always use the analogy, if you were in a restaurant and you ordered a steak and you got hot dogs, would you pay the bill for the steak and leave? No, you'd probably say something right away. This is not what I ordered and I'm not paying for this. Get me what I ordered and then I'll pay for it. That's the way it works in business. So the first thing you need to do is to tell your property manager or your landlord, hey, my refrigerator is broken. And then have them tell you a reasonable time to fix it. If they delay, and I've heard of horror stories of weeks and months at a time, that's unacceptable. I wouldn't go very long without my refrigerator, I can tell you that much. And the same thing with things like water, or if the elevator is broken in your building, and especially buildings that are high rises with seniors and people who are disabled and small children, you have to have these things working. And so what is a reasonable period of time you have to determine, but if you're not getting a response to that in a reasonable, timely manner, you need to file a code complaint for maintenance. If you've being overcharged, if the landlord is coming into your apartment without notice, if you feel you're being harassed, if you feel your rights are being violated in any way, you need to contact the Office of Landlord and Tenant Affairs at 311 for both code and landlord and tenant affairs. And again, the Renters Alliance at info@rentersalliance.org to help navigate any of this and to back you up if needed. Ilana, Branda, there was so much information, but you've been monitoring the chats and the questions. Is there anything else you'd like to add before we begin to wind down from the meeting we thought was going to end early?
Yeah, I think I would just say there was a couple of things people discussing, their personal case. I'm not going to answer those here. So please talk with your caseworker. If your case has not been assigned yet, wait, and you can review with them best options for yourself at that point. And again, if you do have that critical update, you've received a hearing notice from the court, a judgment, or a red and white from the sheriff, or your phone number, email address, contact information has changed, please make sure to update that with us so that we don't deny an application just because of that. And I would just, maybe I'll relink the website. There is a lot of information on our website, document checklist, FAQs, everything. So I think, a lot of other questions would be answered there. If you need a repeat, or I know Matt, I think post these videos, you can rewatch any parts of it also.
Rosie McCray Moody, can you address retaliation for anybody pursuing their rights? And a crazy question I've never seen before, but are children allowed to live above the first floor in an apartment building? I think they
absolutely. Yes, they can.
But one thing we should know,
they may annoy their neighbors, but they can live on every floor.
They can live on every floor. Tell them about the window guard too, though.
Okay.
Actually, Rosie, I'll pick up on the window guard.
Okay.
Okay, because it's connected to that concern potentially about children. There is a window guard requirement. The regulations are being published in the next month. It's going to be effective in January. This was passed by the council earlier this year, and it will require that the landlord provide a notice to every tenant that they can request guards on their windows that prevent the window from opening more than a certain amount, or that protect the window from children with barriers on the inside of the window. These would be installed by the landlord if the tenant identifies that they have a child under the age of 11 years old. So this would be available to any tenant above the first floor that identifies that they have a child, I believe it's under 11 years old, might be 11 or under, and that would be required to be installed by the landlord. So this is something that's coming. You'll be seeing these notices, and strongly recommend that anyone that has children living above the first floor make that clear, and that the installation will provide protection against the kinds of tragedies that we've experienced in the county in the last couple of years.
Frank, is it 11 or 10?
Under 11.
It says under 11, and that's, so
So
it's
that's
10
10
years
or
old.
less.
Right.
10 or less, 10 or less.
Yeah.
But if you're confused, find out what the heck.
Right, you will get a notice, and that will be coming out in the next couple of months.
Oh, and the window guard is installed by the landlord and maintained by the landlord. So
Right.
it shouldn't cost the tenant anything. And if anything happens to the window guard or it doesn't work, notify the landlord immediately, because they're the ones that have to replace it or fix it.
Okay, in 2 minutes or less, can a landlord retaliate against you for pursuing your rights or filing a complaint?
No, they're not supposed to. If they do file the complaint with us, we'll go after.
Retaliation can take a number of forms. That includes reduction of services, harassment, trying to evict you unfairly, anything. If you feel that you've asked for something that you're entitled to, that you've conducted yourself appropriately and are pursuing a right or a promise or required services in your lease, and your landlord starts to take action against you in some way, or property manager or maintenance staff, please reach out to the Office of Landlord and Tenant Affairs, but also keep the Renters Alliance informed. We often can nip these things in the bud, but they're not right, and they unfortunately have a ripple effect throughout entire renter communities. And so they really need to be addressed quickly when we see them. With that, thank you for whoever's posting that information in the chat. Frank, any last words from the Deputy Director?
I always like to say thank you all for attending. I know there's a lot of questions and concerns here. Hopefully we've provided information on how you can get in touch with us, and it's critical that we hear from you. I also like to remind everyone that you've taken the time to listen to this, but you have friends, neighbors, members of your community, that anything that you believe you heard tonight that you need to help others understand, please share that. We absolutely need to reach more of our residents, of our renters who are at risk. Anyone that you know has any concerns about their rent, who's behind. The COVID rent relief program, paying back rent, keeping people from being sued, keeping people who have been sued and have judgments from losing their homes. Our biggest challenge is getting that information out and connecting people with the help that they can take advantage of to understand it. So please share everything that we've shared tonight. Contact us to get more information. The websites for the Department of Health and Human Services, Department of Housing and Community Affairs. If you just put in COVID rent relief, if you put in Office of Landlord Tenant Affairs, it will take you to a lot of this. And we do have the one website I posted that covers a lot of this information, and it's the main county website, Montgomery County md.gov/, that's the right-leaning /renters. So that captures links to all this information and the phone numbers and contacts for the community organizations that can help you together with our Office of Landlord Tenant Affairs. So again, thank you for attending, and please help us share this information, and please give us feedback on and ask your questions and register your complaints so we can deal with the issues directly.
Thank you, Frank. So again, from the Renters Alliance, thank you to Deputy Director of Housing and Community Affairs, Frank Demaray, Senior Staffer at Health and Human Services, Alana Branda, the manager of the Office of Landlord and Tenant Affairs, Ms. Rosie McCray Moody. I have put the info at rentersalliance.org in the chat. If you have any follow-up questions, you can certainly send them to us. Mr. Demaray also put in contact information for his office, and other contacts is the website information. And again, on the 26th of October, our county council is going to vote on whether to extend the rent cap protections, the rent increase cap, the emergency rent stabilization cap for another 9 months. If they don't believe that anybody cares, they're not going to do it. So I urge you, please contact your council member, contact all the council. I put that contact information in the chat. With that, it's 8:30. We started on time and we're going to end on time. We know the conversation's not over. There will be another renter town hall on the 27th of October from the Renters Alliance. And if you go to the website that Mr. Demaray pointed out, you can see the other partners, HIP, CASA, and the LEDC also have their own town halls, which you can participate in. So with that, everybody, thank you very much and good night.